Wait, nobody read me my rights. I should walk. Case dismissed.
Nope, absolutely not. That's not how any of this works. Hollywood has sold people one of the dumbest legal myths of all time, that if a cop forgets to say the magic words, you instantly moonwalk out of jail like the Constitution just handed you a golden ticket. That is not law. That is screenplay nonsense. Miranda rights are real. They matter. They protect one of the most important constitutional rights you have, but they are not a get-out-of-jail-free cheat code. They do not apply to every police interaction, and if officers mess them up, the usual consequence is way narrower than movies make it seem. This all comes from the 1966 Supreme Court case Miranda versus Arizona. Ernesto Miranda was arrested, interrogated for about 2 hours, and gave a written confession without being fully warned about key rights, including the right to counsel during questioning. The Supreme Court said prosecutors generally cannot use statements from custodial interrogation unless police first use procedural safeguards, those familiar warnings about remaining silent and getting a lawyer. And this is the key point. Miranda was created to protect people from the coercive pressure of concustody police questioning. It was about guarding the Fifth Amendment privilege against self-incrimination, not creating a hyper-technical loophole where every arrest vaporizes because an officer forgot to read from the card fast enough. Also, fun fact, Miranda himself was retried without the confession and convicted again. So even the case that gave us Miranda rights is basically screaming, this does not automatically make the whole prosecution disappear. Here is the legal rule everybody mangles. Police do not have to read Miranda rights before every arrest, every stop, or every conversation. The warnings are required before custodial interrogation, meaning 2 things have to be true. First, you're in custody or otherwise deprived of freedom in a significant way. Second, police are interrogating you, meaning direct questions or the functional equivalent designed or reasonably likely to get an incriminating response.
License and registration. Have you had anything to drink tonight?
This is why nuance matters. A routine traffic stop is usually not considered Miranda custody. It's temporary, public, and generally less coercive than a station house interrogation. So no, the officer does not have to start every speeding ticket with a dramatic TV monologue about your rights.
You're under arrest. Sit down. Where did you put the gun?
Now, this is the zone Miranda was built for. You're in custody and police are asking questions likely to produce incriminating answers. That is when the warning requirement kicks in, and interrogation is broader than just asking, did you do it? If officers say or do things they should know are reasonably likely to make you incriminate yourself, that can count too. Now for the part movies get hilariously wrong. If police fail to Mirandize someone before custodial interrogation, the automatic result is not the arrest is invalid, and it is not case dismissed. The usual consequence is evidentiary. Specifically, the prosecution generally cannot use that unwarned custodial statement in its case-in-chief at trial. That's the exclusionary effect people are trying to talk about, but Hollywood inflates it into total legal annihilation.
Aha! No Miranda warning. Therefore, now I'm legally invisible.
No. What you may have is suppression of the statement from that interrogation. That matters a lot. Confessions are powerful, but it does not magically erase probable cause, undo the handcuffs, delete the police report, or laws the judge to launch the file into the sun. The issue is usually whether that statement comes into evidence, not whether the entire case ceases to exist. And here's the prosecutor's favorite sentence. We have other evidence. If the unwarned custodial statement gets excluded, the government may still proceed with physical evidence, surveillance, fingerprints, eyewitness testimony, or statements the suspect volunteered before custodial interrogation began. In United States v. Patain, the court held physical evidence derived from a voluntary unwarned statement could still be admissible. So if you thought forgetting Miranda means the whole case evaporates, again, that's a movie ending, not a courtroom ending. So, here's the takeaway. Miranda rights are real, important, and constitutionally significant, but the law runs on precedent and nuance, not dramatic one-liners from a cop show written at 2 a.m. by somebody whose criminal procedure class was apparently just binge-watching cable. No, police do not have to read Miranda rights before every arrest. No, forgetting the warning does not automatically set you free. And yes, the actual remedy is usually much narrower than people think. Suppress the unwarned custodial statement, then ask what evidence is left. This is general information, not legal advice. Follow for more legal myth-busting, because the truth is usually less cinematic, more complicated, and way more interesting.